President Obama's findings and conclusions that torture is not only a horrible crime, but also a totally ineffective practice. And could the delegation elaborate also on the similar assessment made in the Army Field Manual, which actually sounds as a conclusion reached out of many years of experience? In other words, are there documents or reports in the United States making an analysis of the practice of torture and demonstrating its ineffectiveness in the positive? Can they be shared with this committee? Now, I'm referring to the statement of President Obama of 1st August this year, which was already quoted many times and also today in the introduction. But it's good to repeat it because then I will develop a certain reasoning on this statement. When we engage in some of these enhanced interrogation techniques that I believe and I think any fair-minded person would believe were torture, we cross the line. We have to, as a country, take responsibility for that so that hopefully we don't do it again in the future. I do appreciate the realistic approach of President Obama, but I would like to know what concrete measures have been taken to implement his clear position against the practice of torture since August 2014. I would like to know, in particular, what progress had been made towards the publication of the rendition, detention, and interrogation report prepared by the Senate Select Committee on Intelligence. There was a mention of it during the introductory statement this morning, but no dates were given. No planned dates were given. My latest information on this subject is that a further extension at the time before the before the publication of the report was requested on 25 September 2014 by the government until 29 October 2014. And then what happened? I think the public opinion is expecting this document, and it deserves to give a certain plan and dates. As I mentioned before, President Obama considered that enhanced interrogation techniques are, in fact, a form of torture. Are those techniques subject not only to presidential disapproval, but also to new administrative and legal measures envisaging the prosecution for those who would be responsible for the so-called enhanced interrogation techniques, if they are still practiced? Now I would like to come to certain issues more relating to Articles 1 and 4 of the Convention. It is stated in the reply to question 1, and I quote the report, "The Convention does not require state party to enact a crime labeled torture per se. To explain its position, the government gives examples of legal provisions which, according to it, show that every act within the meaning of the Convention is criminalized under federal and/or state law. However, I noticed that there is a bill entitled Law Enforcement Torture Prevention Act, which was presented to Congress, and it contains a definition of torture, and it was submitted in 2010, the first submission. Then I know that debates are going on, but I would like to know what is the status of this bill today. In reply to question 2 of committee's list of issues, the report refers to the reservation made by the United States government at the time of ratification of the Convention, according to which, and I quote, "In order to constitute torture, an act must be specifically intended to inflict severe physical or mental pain or suffering, and that mental pain or suffering refers to prolonged mental harm. My first question is, what is meant by prolonged mental harm? 1 day, 1 week, 1 month? I would appreciate it if the delegation could explain this expression, prolonged mental harm, by giving the exact duration of a mental harm which is considered prolonged. The statement in the reservation specifies 4 forms of this kind of prohibited practice. The first of them, the intentional infliction or threatened infliction of severe physical pain or suffering. In other words, these expressions identify what is considered precise torture for the United States. Could the delegation indicate whether, at present, enhanced interrogation techniques are or will be included in this category of actions provoking severe physical or mental pain or suffering, now that they have been categorized as acts amounting to torture by the President of the United States? Furthermore, it is stated in paragraph 13 of the report that under United States law, officials of all government agencies are prohibited from engaging in torture at all times and in all places, not only in the territory under United States jurisdiction. This commitment was underlined also this morning in the introduction, and all this, I find this very laudable. But I would appreciate if the delegation could give example of prosecution of public officials violating this legal provision, which is contained in Section 1003 of the Detainee Treatment Act. However, nothing is said, apparently in the law, or I didn't find anything, about delegating the task of torturing to entities external to the United States administration and not involving United States officials, directly at least. I'm referring, of course, to the phenomenon well known of extraordinary renditions, which during the war against terror allowed U.S. officials to apprehend and transfer extrajudicially persons suspected of terrorism from a country to another, where the U.S. officials were aware that torture was practiced for the purpose of interrogation. This phenomenon has been reported and documented by many sources. I will refer here only to one of them, the Council of Europe, which is an authority. In a report of June 2006, the Council of Europe estimated 100 people, that 100 people had been kidnapped by the Central Intelligence Agency in the European territory and rendered to other countries, often after having transferred them through secret detention centers known as black sites. Another report issued by the European Parliament in February 2007 refers to 1,245 flights organized by the CIA to transfer suspects to countries where they could face torture in violation of the Convention Against Torture. This is what the European Parliament said. Now, I would appreciate the comments of the delegation on the practice of extraordinary rendition, and I would like to know if any measure has been taken in the United States to publicly condemn this practice. Now, I have some questions relating mostly to Article 2, but could be even 11. On the issue of registration of all persons in detention, it is stated in paragraph 15 of the report that according to the United States, the Convention has no provision requiring the registration of detainees. Let me underline that Article 2, paragraph 1 of the Convention refers to the obligation of each state party to take effective measures to prevent torture. This committee considered that registration of a detainee is a first step to prevent torture, since his or her identity and location are a sort of deterrent against any form of ill treatment which needs secrecy to be carried out with total impunity. I wonder why the United States considered that registration of detainees is not a requirement among the measures to prevent torture generally indicated by the Convention, particularly because if registration is not to be considered as one of the basic requirements to prevent torture, I see some contradictions with the statement in paragraph 26 of the report of the United States, which says the United States does not operate any secret detention facility. Let me observe in this regard that any place where a person is deprived of his or her liberty, regardless whether it is a legal or well-known place of detention, becomes a secret place of detention if the person is arrested, is not properly registered there as detainee. And in this connection, I would like to know which are the regulations concerning the detention facility used by the CIA to hold people on a short-term or transitory basis. Are these detainees registered there? The replies to questions 6 and 7 of the committee list of issues reaffirm the principle that U.S. officials are prohibited from engaging in torture or ill treatment at all times at all places. The only appropriate guidance, and this was repeated this morning on interrogation, is given by the Army Field Manual or Human Intelligence Collector Operation of September 2006, which, according to Executive Order number 13491 of President Obama in January 2009, is extended to any official acting for the U.S. government, just to put the things clear, let's say. Now, this document includes permissible interrogation techniques, one of which, although exceptional and subject to particular authorization, is the technique of separation applicable in the framework of the war of terrorism. The purpose of separation, and I'm quoting from paragraph 26 of the manual, is to deny the detainee the opportunity to communicate with other detainees in order to keep him from learning counter-resistant techniques or gathering new information to support a cover story, decreasing the detainee's resistance to interrogation. Now, there are two types of separation: the physical separation and the field expedient separation. I will concentrate on the first method. I think that Mr. Mopni maybe will raise question on the second method. Physical separation may last for an initial period of 30 days, but this period may be renewed upon appropriate authorization, and it must not preclude the detainee from getting 4 hours of continuous sleep. Now, two questions come to my mind in this connection. Is a sleep limited to 4 hours a day for 30 days or more a form of ill treatment? Although the necessary amount of hours of sleep may vary individually, 4 hours are definitely insufficient for a majority of people and over a long period of time. So I would like to know from the declaration, what is the purpose of this limited amount of sleeping hours allowed to a detainee? Because we learned from the manual that the purpose of the separation technique is to deny the detainee the opportunity to communicate with other detainees. So why to prevent a detainee from sleeping a sufficient number of hours? I don't know. Would his prison guards be afraid that he communicates with others while he's sleeping? I would appreciate some clarification of the delegation on this point. Always on the subject of technique of interrogation, I note from the report that a high-value detainee interrogation group has been established to interrogate the most dangerous terrorists. A very laconic sentence in paragraph 124 of the report concludes that interrogations conducted or supported by the high-value detainee interrogation group are consistent with the provision of the Convention Against Torture. Well, it seems to me difficult for our committee to agree to such an assessment without being informed in details of the methods used by the group in interrogations. If those methods cannot be disclosed, then the statement that they are consistent with the provision of the Convention cannot be verified and would be groundless. I would like to have the comments of the delegation also on this point. Now, I come to the issue of closing Guantanamo detention facility. The report informs us that there were 166 detainees in Guantanamo in 2013. If I understand correctly many reliable sources, they should be 149 at present. Now, I would like from the delegation to know exactly how many are they today, but in particular, how many are waiting for their transfer to another country? B, how many are subject to prosecution in the United States? C, how many have been designated for continued law of war detention? D, how many are still kept in detention because they are suspect, but they have never received a formal charge against them? With regard in particular to those prisoners who have been charged before military commission, I would like to know in particular whether they have the same legal guarantees as provided for in ordinary courts. That is to say, whether they have the same guarantees for a fair trial. We all know that it was President Obama's intention at the beginning of 2009 to close Guantanamo within 1 year, but for a series of reasons this could not be done. In his State of the Union address, of January 2014, President Obama underlined the urgency of closing Guantanamo detention facility before a joint session of Congress. What is the situation of this issue today? Does the United States have a specific plan and timetable for the closure of Guantanamo? What is that plan and timetable? In this connection, I would like to refer again to Section 1003 of the Detainee Treatment Act. It provides that, and I quote, "No individual in the custody or under physical control of the U.S. government, regardless of nationality or physical location, shall be subject to cruel, inhuman, or degrading treatment or punishment." Fine. But how the U.S. government can reconcile this provision, clear provision, for instance, with the practice of force feeding of Guantanamo prisoners who are on hunger strike to protest against their living conditions in detention? I understand that a federal judge, Judge Gladys Kessler, blocked the practice of force feeding last May and ordered the government to unseal 28 videotapes on that practice last October. What happened then? Is the government going to disclose those videotapes, or is the government's view that security consideration can be used to extinguish the right to complain about torture and ill treatment and to obtain redress? Finally, on this point, I wish to refer to the several requests made by the Special Rapporteur of the Human Rights Council on torture to visit Guantanamo detention facility. The U.S. authorities have put forward a major restriction to a possible visit, that the visit does not include private meeting with the so-called detained enemy forces. This clause was found unacceptable by the Special Rapporteur. So I have just a simple question on this subject. What is the reason for the refusal of private meetings between the Special Rapporteur or the detainees in Guantanamo? Security reasons? I don't see it. But I will wait for the explanation of the delegation. Now some issues related to Article 3 of our Convention. It is stated in the report that the United States policy is not to transfer any person to a country where it is more likely than not that the person will be tortured. As I mentioned before, the allegations of violation of this statement and Article 3 of the Convention through the practice of extraordinary renditions are numerous. Nonetheless, could the delegations give examples of persons not transferred from the United States to another country because they were in danger of being tortured, and how the decision was taken? It is also stated in the report that the United States may secure diplomatic assurances from the country of proposed transfer, as well as post-transfer monitoring of the detainees. Now, it is the opinion of this committee that diplomatic assurance can never replace the principle of non-refoulement. If those assurances are requested, it means that there are serious suspicions that torture is practiced in the country where the detainee is to be deported. According to the United States authority, diplomatic assurances which have been requested have never been violated. But what would be the incentive of the government to acknowledge a breach of diplomatic assurances? Such an acknowledgement would not only amount to the admission that the government has violated the absolute prohibition of torture by sending people to places where they were at risk of torture, but of course it would be likely to complicate its efforts to rely on assurances in the future. But let me focus on one question. I understand from the report that the United States does not, as a general matter, publicly release the names of countries from which it has secured assurance. Fine. However, there is a list of 45 countries of destination for Guantanamo prisoners since 2002 in paragraph 46 of your report. Have any of them been requested to give diplomatic assurances for the treatment of Guantanamo prisoners, or they have been considered, all of them, as safe countries without distinction? Finally, on this issue of non-refoulement, there is the dramatic phenomenon of unaccompanied children entered the United States illegally. Apparently, from October 2013 to September 2014, there were more than 68,000 apprehended at the border between the United States and Mexico, and coming mainly from El Salvador, Guatemala, Honduras, and Mexico, to avoid all sorts of violence and abuses. In addition, also more than 68,000 family units coming from more or less the same countries and illegally crossing the U.S. border were apprehended. According to reliable sources, the majority of them have been placed in detention for extended, I would say, unlimited period of time, or immediately expelled without identification. Is the delegation in a position to give precise information in this regard? There are some other important issues which concern Articles 2, 11, and 16. But allow me to spend a few words on one of these big issues, which is death penalty, which in certain circumstances may amount to torture of at least inhuman and cruel punishment. We all know that in the United States, prisoners sentenced to death spend often many years in the death row before the sentence is executed, and in some rare cases cancelled. This is mostly due to the numerous recourse procedures available before the execution takes place. But isn't this uncertainty about their fate for many years a kind of and I quote, prolonged mental harm caused by or resulting from the threat of imminent death, which is considered one of the 4 forms of torture included in the declaration and reservation made by the United States at the time of ratification of the Convention. I would appreciate if the delegation would be able to comment this point. Apparently, this view has been recently supported by an American judicial authority. I'm referring to Federal Judge Cormac Carney of California, who in July 2014 ruled that California's death penalty system, with its continued delays lasting for many years, violated the 8th Amendment of the U.S. Constitution, prohibiting cruel and unusual punishment. He therefore considered that California's death penalty system was unconstitutional. Does the delegation share Judge Carney's view? Does the delegation think that times are mature to consider a moratorium, at least a moratorium, of death penalty? And of course, here I will not expand much on lethal injections. We all know about this problem, which cause prolonged suffering, and even the execution of death penalty by electric chair, which was reintroduced as an alternative to lethal injections in Tennessee from May 2014. The question is clear. Are these executions violating the 8th Amendment of the Constitution or not? Now, another big issue on which I wish to elaborate is the living conditions in detention. In May 2012, President Obama issued a presidential memorandum stating that the Prison Rape Elimination Act 2003 applies to all federal confinement facilities. What the consequences of this memorandum are in practice? Are there any tangible results towards the decreasing and possibly the elimination of rape in prisons? Are there recent examples of prosecution for rape in confinement facility? And what about state prisons? Is the Prison Rape Elimination Act applicable there? Apparently 90% of the detainees are in state prisons, so they would be excluded from the protection of this act if it is not applicable to state prisons. But I'm asking the question because NGO information quoting the Department of Justice, and here we have the representative of the Department of Justice, indicates that only 2 states, namely New Hampshire and New Jersey, have actually certified compliance with the Prison Rape Elimination Act standard. 46 states and territories have promised to work towards compliance. 7 have not made any promise, and 5, Arizona, Idaho, Indiana, Texas, and Utah, have simply refused to comply with the standard. But so my question is because as a state party, although it is a federal state, but the United States of America is in a position to fulfill all its obligations vis-à-vis the Convention or not? Because apparently there are certain orders, certain law, but they don't touch the states, just the federal city, the states. But vis-à-vis the Convention, there is only one state. And so I would like if the delegation could elaborate about its obligation as monolithic obligations, without any escape, but the state can do the contrary or otherwise. Now, another matter of concern is the living conditions in the super maximum security prison, such as the penitentiary Florence Administrative Maximum Facility in Colorado, or the Louisiana State Penitentiary, also known as Angola prisons. I'm aware that the worst of the worst criminals are incarcerated in those types of prisons, but I would like to know the reason why inmates of the Florence prison, for instance, are kept in full isolation for 23 hours a day for prolonged periods which may last for years. It is reported also that in Louisiana State Penitentiary there are prisoners in solitary confinement for over 30 years. Today in the introduction, some measures were mentioned in this regard about the Pennsylvania, Louisiana. No, I don't remember. Well, anyway, but I want to underline that apparently, although there are not precise data, this measure of solitary confinement would concern at least 25,000 prisoners, which is an incredible amount. And I would appreciate
Mr. Bruni,
that
you have one more minute. Sorry.
This information. Now, how many?
I will try to allocate some more time for you at the end if there is something remaining. So.
Okay. Okay, I will try to speed up my speech. I want to recall simply that the Special Rapporteur on torture has made a deep study on solitary confinement, and this solitary confinement develops symptoms of anxiety, depression, hallucination, up to total insanity. And I wonder whether this is the purpose of the harsh regime imposed into the maximum security prison. I will skip some other. Now, let me please elaborate on an issue which I think is important. The issue of living conditions in detention brings me to the related issue of overcrowding of prisons. Now, actually, there are numerous reports on this issue in the United States, but I will focus just on one official document. I'm referring to the report prepared by the Congressional Research Service entitled The Federal Prison Population Buildup, which was addressed to members of and Committee of Congress in April 2014. I will skip the analysis of the overcrowding. Perhaps I can elaborate it later. But I will go to the question of recommendations made to solve the problem of overcrowding, which are increasing the capacity of the federal prison system, investing in rehabilitative programs, modifying mandatory minimum penalties, expanding the use of residential reentry centers, placing more offenders on probation, reinstating of parole for federal inmates, expanding the amount of good time credit an inmate can earn, and repealing federal criminal statutes for some offenses. Have any of those suggestions been accepted by Congress, and what the government does about overcrowding? May I conclude? I have 1 minute more.
Mr. Bruni, you already used 37 minutes. So, yeah, I've been very tolerant in this case. I have to pass now the floor to the second rapporteur, and I will try my best to give you some more time at the end, I promise. So, Mr. Modvik, the floor is yours.
Thank you very much, Chair. I would like to warmly welcome the high-level delegation from the United States, and I'm looking forward to a constructive dialogue about the obligations of the State Party, which relates to Articles 10 to 16 in the Convention. These are the obligations to train law enforcement and medical staff in the prohibition of torture, the obligation to investigate alleged cases of torture, the obligation to provide redress, including rehabilitation to victims, the inadmissibility of evidence evoked by torture, and the obligation to preventive treatment, and others. I appreciate the introductory remarks regarding applicability of the Convention. For reasons of clarity, I would appreciate an elaboration. The committee is interested in learning whether, as a legal matter, the state party considers the convention to apply to territories over which the state has de jure or de facto control, as provided in the General Comment 2. While it's welcomed that all U.S. personnel are prohibited from carrying out torture anywhere in the world and from engaging in ill treatment of individuals under their physical or effective control, the committee would like a clarification as to whether the U.S. considers all aspects of the convention to be applicable to territories under the de jure or de facto control of the state. As for the applicability during armed conflict, does the U.S. position regarding the applicability of the CAT during times of armed conflict, as set out in paragraph 14 of the State report, represents a shift in its position from that taken during its previous review by the committee? Please clarify the status of the application of the Convention Against Torture to the detention facility at Guantanamo Bay, which is under the effective control over the United States. The State report refers to Guantanamo detainees as law of war detainees. However, as stated in the State report, the protections provided by the Convention Against Torture are not suspended in a time of war, and therefore law of war detainees should enjoy all the protections and safeguards that flow from the Convention, including the right to fair trial, to access an attorney of their choosing, to complain about acts of torture, to communicate freely with their legal counsel, to have access to evidence used against them so that they may mount a defense, and so on. Please explain why some detainees at Guantanamo are denied these rights in light of the application of the CAT during times of war. As for the obligations to include the prohibition of torture in training and education, in the report paragraphs 94 to 100, the State Party informs about the training and the reporting obligations of Department of Defense interrogators, FBI agents, Bureau of Prisoners employees, Customs and Border Protection, Immigration and Customs Enforcement special agents, and medical staff associated with agencies involved in detainees. We would appreciate information on the impact of the training conducted for law enforcement officials, prison staff, etc., and how effective the training programs have been in reducing incidents of torture, violence, and ill treatment. We would also like to know to which degree the Istanbul Protocol is included in the training programs, as well as if any training was conducted for CIA agents in the prohibition of torture. As for the reporting obligations mentioned, that is, reports of torture and ill treatment submitted by DoD intelligence officers, reports by FBI agents on mistreatment and abuse, reports by Bureau of Prison employees on inmate injuries, reports by Immigration and Customs Enforcement special agencies, and reports by medical personnel in agencies involved with detainees on signs of abuse and neglect, which has been a part of the training. Please inform about the number and outcomes of these reports with respect to investigations, prosecutions, and punishments which resulted thereof within the reporting period. In paragraph 104, the State Party explains that also misconduct in Department of Justice, Bureau of Prisons facilities must be reported to internal investigative staff. Please provide information about the number of such reports during the reporting period and their outcome. In paragraph 105, the State Party explains that the principles of medical ethics relevant to the role of health personnel is complied with. Medical ethics is relevant for inter alia the hunger strikes that have been experienced in Guantanamo as a sign of desperate objection to the treatment. How many detainees is currently hunger striking in Guantanamo, and which considerations have been given to the demands of the hunger strikers? The guidelines for medical management of detainees on hunger strike have been made public and clearly describe the procedures for initiating involuntary medical treatment. This includes shackling of the detainee, and placement of mask to prevent spitting and biting, placement in a so-called chair restraint system, as well as forced insertion of a feeding tube, if required, while a guard from behind holds the head of the detainee. I would appreciate if the State Party would comment on the medical ethics of this practice, which raises concerns about practice of ill treatment or even torture. In this connection, I understand that detainees in the US in general do not have the right to be examined by an independent doctor. Rather, medical services to detainees and prisoners are provided by doctors and other health staff employed by the authorities in question only. This raises the important issue of so-called dual loyalties, which is medical dilemmas well described in the Istanbul Protocol. What counts the most? The expectations of the employer of the doctor, or the concern to address the needs of your patients, security or health? It's concerning that this basic right to see a doctor of the detainee's own choice is deprived all detainees and prisoners in the US, if correct. It makes it difficult for the detainee or prisoner to know if there's access to a doctor, if it's doctor's advice or doctor's orders based on medical science, or rather emerge from security concerns. It raises concerns about medical integrity and also of medical confidentiality. In other words, concerns about most, if not all, aspects of the basic principles of medical ethics. This is important in relation to the Convention because we need medical doctors in detention settings to be able to freely document and report cases of torture and ill treatment and not worry about negative reactions from their employer. I would appreciate the State Party's comments to the concerns made about medical ethics regarding the practices of the State Party. According to the Army Field Manual, the separation technique includes field expedient separation, which aims to prolong the shock of capture by utilizing goggles or blindfolds and earmuffs to generate a perception of separation. The duration of this treatment is 12 hours, not including time where goggles or blindfolds and earmuffs are used for security purposes during transit and evacuation. Extensions past the 12 hours of initial duration must be reviewed by the servicing staff judge advocate. Considering that recent research has demonstrated that deprivation of visual and auditive stimuli creates psychotic symptoms with most people after as little as 25 minutes deprivation, the described procedure for field expedient separation for many hours raises concerns whether this practice is in accordance with the Convention. Please comment on this and provide information about the number of times the field expedient separation were used during the reporting period and how many of these cases represented an extension of the 12-hour maximum. Do any of the procedures include a medical assessment? If so, please inform about the results of these. Continuing questions regarding the Army Field Manuals. Is the CIA authorized to interrogate detainees at short-term or transitory facilities? If so, is the CIA restricted to the interrogation techniques and approaches set out in the Army Field Manual? Please also clarify if the Army Field Manual includes all of the procedural obligations that flow from the Convention, including the right to undergo an independent medical examination and access to a lawyer from the outside of detention. Moving to accountability of the police, which steps has the State Party taken by both the federal and state governments to review the police practices following the recent events in Ferguson? Please also provide information about what steps, if any, have been taken to review the distribution of military equipment to local police forces and to review police practices regarding the use of such equipment. Which mechanisms of independent oversight and accountability apply in general to ensure the prevention of excessive use of force by the police? We understand that the police review boards are elected by city governments and thus are not properly independent. More specifically, how is oversight and accountability implemented, for instance, as to the use of firearms and taser guns by the police? In paragraph 129, the State Party mentions that more than 100 service members of the armed forces have been put before a court-martial for mistreatment of detainees. The period within which this took place is, however, not provided. Could the State Party please inform about the number of such cases processed during the reporting period, the charges presented, and their outcomes in terms of convictions and disciplinary sanctions, as well as reparations? In paragraph 1 and 2, the State Party gives an account of the conviction of Commander John Birch, who himself had tortured several persons and under whose leadership police officers administered electric shock to genitals of victims and used other forms of torture. Please provide an update of the case against other CPD police officers, as well as the redress provided to victims. In paragraph 144, the committee is informed about the habeas corpus jurisdiction has been extended. Which persons under effective U.S. detention, citizens or not, kept inside or outside the U.S. territory, have not been extended the opportunity of habeas corpus review, and what is the reason for that? Do the extensions imply the right to assistance of a counsel of their choice? And does it imply access to free legal assistance if they require it? Moving now to the obligation to investigate. According to the Convention, each State Party shall ensure that any individual who alleges he has been subjected to torture in any territory under its jurisdiction has the right to complain to and to have his case promptly and impartially examined by its competent authorities. Will the State Party consider meeting this obligation by investigating all credible allegations of torture during U.S. custody? In paragraph 155, the State Party addresses the possibility which Guantanamo detainees have to raise complaints, either via ICRC or directly with the U.S. military at Guantanamo. Please provide information about the number, the nature, and the outcome of the complaints in terms of investigation, prosecutions, and punishment raised through either of these mechanisms during the period of review. In connection with the Durham preliminary review, please clarify the number of cases that were examined in the preliminary investigations and the basis for determining that further investigation into these cases, with the exception of 2, was unwarranted. Please also provide information on the total number of investigations into cases of torture and ill treatment by any U.S. officials were initiated in the period under review, both on the basis of complaints as well as ex officio, and the number that led to prosecutions and with which outcomes, if any. Why did the investigation not include victims of torture, for instance, former Guantanamo detainees? This could have contributed greatly to enlightening the torture committed. Moreover, please explain the measures taken by the State Party to ensure investigation and prosecution of those responsible for CIA interrogations of suspected terrorists, including senior officials and those who provided legal cover for cases of torture or ill treatment of detainees in U.S. custody outside its territory, and for the use of brutal interrogation techniques. Please also comment on reports that indicate that the State Party continues to invoke claims of immunity for government officials and state secrecy laws to evade liability, and that any information relating to the detainees' time in secret detention, apart from the date and place of their capture, remains classified. Please provide updated information on the investigation and related prosecutions for the destruction of evidence, such as videotapes documenting torture by CIA personnel. Moving to Article 14, the right to reparation. Here, in a storm of questions, I would like to commend the State Party for its commitment to support rehabilitation of torture survivors via inter alia support for rehabilitation centers within the USA. Indications are that rehabilitation of victims of torture, apart from the compassionate aspects, is a good public health investment which prevents later healthcare needs and contributes to a future productive life. Still, the capacity within the US does not match the needs based on estimates of torture victims currently residing in the US and the existence of long waiting lists with almost all centers. In light of this, will the State Party consider increasing domestic availability and access to rehabilitation services and entering into a collaboration with the existing services to develop standards of care and monitoring and evaluation of the rehabilitation activities? As for victims of torture at the hands of the US, the picture is much different. The State Party informs that various avenues exist for obtaining redress, including rehabilitation for acts of torture. However, lawsuits brought by persons alleging torture while in US custody are hindered by claims of immunity for government officials or state secrecy laws. Could the State Party please inform how many victims of torture have legally pursued and successfully obtained effective remedy for torture during US custody within and outside US territory, respectively within the reporting period? How many victims of torture formerly detained in Guantanamo has received judicial remedy for their treatment? As for the Protective Order 1, high-value detainees who are victims of torture are prevented from seeking remedy because of classification of the information surrounding their treatment. Could the State Party please explain why victims of torture are silenced this way, prevented from seeking remedy with reference to state security, even including remedies abroad? In paragraph 147, the State Party provides a table of 33 persons who filed claims against the Department of Defense. Please inform if this list contains all cases and forms of redress that has been and will be provided by the State Party to the victims of torture in Abu Ghraib. Have victims, for instance, been informed about the possibility to obtain redress? If so, how and when did this happen? And please provide an update of the status of these cases now 8 years later. Does the State Party intend to launch more efforts to ensure that the victims of torture in Abu Ghraib receive redress? How many individuals have been provided non-judicial remedies for torture by the State Party? Moving to the Prison Litigation Reform Act, in paragraph 149 to 151, the State Party informs the committee about the provisions in section 1997EE of the 1995 Prison Litigation Reform Act. Could the State Party please provide an explanation to the committee as to why a mental injury during confinement without a physical injury or sexual act does not justify monetary compensation? Does damage of the mind not mean as much as damage to the body? Referring to the requirement of exhausting the internal grievance system before a prisoner may file a lawsuit, I would appreciate information about how many lawsuits alleging torture or ill treatment have been dismissed because this requirement was not complied with. As for inadmissibility of coerced confessions, please provide the committee with information about the specific measures adopted to ensure that the principle of inadmissibility of evidence obtained through torture is observed in practice, including detailed information regarding the procedures through which an allegation that evidence was obtained through torture is addressed by the courts. Please provide examples of cases that have been dismissed by courts because evidence or testimony obtained through torture or ill treatment was submitted. Please provide information about measures taken that coerced evidence is not admitted as evidence in military commissions trials at Guantanamo. Regarding Article 16 on ill treatment, in general, when a State Party fails to establish effective mechanisms of transparency and accountability in law enforcement agencies to prevent torture and ill treatment, there is a great risk of impunity for perpetrators of such actions. In order to establish effective prevention of torture and ill treatment, will the State Party consider allowing civil society organizations to monitor places of detention, i.e. jails, prisons, immigration detention facilities, and psychiatric wards? And will the State Party extend an invitation to the UN Special Rapporteur on Torture to visit your country with full access to information. As for sexual victimization of inmates, in Annex 1 to the periodic report, the State Party provides data about the prevalence of sexual victimization of inmates. According to this information, more than 40,000 adult inmates reported at least one case per year of staff sexual misconduct, whereas 1,319 juveniles reported such misconduct. Please inform how many cases of alleged sexual misconduct among correctional staff were actually reported, investigated, prosecuted, and punished during the reporting period. And also please inform about intended measures to prevent sexual abuse of detainees everywhere in the US, thus preventing detainees and prisoners of having an extrajudicial additional sexual abuse punishment. There are concerns as to notable gaps in the protection of juveniles in the State Party's criminal justice system. Please inform the committee about the number of minors who are detained or imprisoned in adult jails and prisons, and also about the number of minors subjected to physical and sexual violence in the reporting period. As for the LGBTI area, in the area of LGBTI persons, which protective measures are in place in terms of preventing ill treatment in the criminal justice system and also in the healthcare system, for instance via so-called conversion therapy, which is allegedly still in use. As for sexual violence in the military, what are the measures that the State Party intends to take in order to ensure investigation, prosecution, and punishment, as well as prevention of sexual violence in the US military? Can victims bring civil rights or personal injury claims against the military or military officials into civilian federal courts? Please comment on reports about difficulties faced by veterans who are survivors from sexual assault in getting disability benefits relating to sexual trauma. The very serious sentence of life sentence without parole is allegedly applied to more than 3,000 people for non-violent offenses, and in some cases also to minors. Which steps will the State Party take to avoid that this practice is applied in cases of non-violent offense or minors? As for the use of solitary confinement, please explain the rules and regulations that apply to the use of solitary confinement, that is 22 to 24 hours a day in the same room, alone, a practice that is well known to have a negative impact on the mental health of detainees, particularly when applied indefinite. What are the legal safeguards, including appeals that apply to detainees and prisoners subjected to solitary confinement? Which time limits exist? Which measures of socially meaningful activities are obligatory? And what are the rules for confining minors and persons with mental health disorders?
Mr. Modwick, 1 more minute.
Thank you. I would also appreciate if the State Party would provide the number of suicides, attempted suicide, and other self-harm during the reporting period among detainees and prisoners held in solitary confinement. We have information about at least 12 heat-related deaths recorded since 2007 in 9 different Texas prisons. Could the State Party please provide information about the number of deaths in custody during the reporting period, including the causes of death, the procedure for independent investigation of death in custody, and the outcome of investigations in terms of sanctions and prosecutions and preventive measures arising from the investigations? Thank you very much, Chair.
Thank you, Mr. Modwick. And now let me ask the committee members, the ones who wish to take the floor. We have 5, and me. 5, 6, 7. We have some, I would say, around 40 minutes left. Thank you. So we have 6 members wishing to take the floor. I can provide 3 minutes to each, including myself. So, Mr. Zhang, the floor is yours.
Thank you, Mr. Vice Chair. I would like to join my colleagues in welcoming this distinguished delegation to come to this and also to send a
Thank you, Mr. Vice Chair. I would like to join my colleagues in welcoming the distinguished delegation from the United States and to thank them for providing us with a comprehensive report. And, well, I would like also to welcome the positive development in the legal and policy framework around immigration detention and the ongoing cooperation and facilitation of the UNHCR's detention monitoring mission by the United States. And I have just a couple of comments regarding the information provided under Article 10, Article 11, Article 15. And I noticed in their paragraph 97 of the report, they indicated the specific FBI policies on interrogation covered by this by the training which they described above. And then they also indicated in the last paragraph of this paragraph 97, which is a reporting system if there's an incident like this occurred, the interrogation through illegal means. So I wonder whether the delegation can provide data information for this kind of incidents. And secondly, I noticed under Article 11, in paragraph 108, 109, and 110, when they provide information on the actions prohibited by the Army Field Manual with respect to the intelligence interrogations, and then which is a very good law, and I found it very encouraging. My questions are: first, whether the delegation can provide a copy of the manual, and secondly, can the CAT be provided with the information on cases of on implementation of the manual? And regarding 15, Article 15, I noticed that it is indicated in paragraph 154 in both the Constitution and the other relevant laws that this principle of exclusion of evidence obtained through illegal means are tackled. So I wonder whether you can provide further information on more cases in addition to those two provided in paragraph 157, and most importantly, how are the victims of torture compensated? Actually, victims who were convicted due to the evidence obtained through illegal means, and how they are compensated, which is my question. And if I have one... No,
Mr. Zhang, your time is out.
Yeah.
So let me now pass the floor to Madame Belmir. Vous avez la parole, Madame Belmir.
Merci, Monsieur le Président. Je salue à mon tour la délégation de l'État partie. Je lui souhaite un bon séjour à Genève et on la remercie pour les informations données par les documents transmis que par les informations qui ont été données aujourd'hui dans les discours d'ouverture. Je me permets de poser quelques questions concernant les méthodes d'interrogatoire. Bien sûr, il y en a d'autres questions, mais les plus importantes, c'est les questions concernant les méthodes d'interrogatoire prévues dans le manuel de terrain des armées. Il y a beaucoup de qualificatifs qui sont donnés dans les réponses de l'État partie à la liste des points concernant ces méthodes. On parle de méthodes efficaces, méthodes qui sont non coercitives, qui sont licites. Bon, un tas d'adjectifs qui sont accordés à ces méthodes. Et puis on parle vraiment de méthodes d'interrogatoire pour les détenus de haute importance. Et on cible les terroristes les plus dangereux. Ma question est que vraiment les gens qui se trouvent à Guantanamo font partie de cette catégorie, ou est-ce que c'est exclusivement réservé à ces personnes ou à d'autres personnes? Parce qu'on sait très bien que pour l'État partie, l'étendue de la juridiction de sa juridiction vraiment prend un aspect assez particulier. On parle vraiment du message du président de l'État partie qui parle vraiment de tenir compte de la dignité des personnes détenues. Et on parle d'un certain nombre d'interdits. On n'a pas besoin de les évoquer parce qu'ils sont dans les paragraphes 107 et 108 des réponses. Et ces actes interdits ont été, au moins vraiment du temps vraiment de la présentation du rapport de l'État partie en 2006, était vraiment en cours. On a fait état d'un certain nombre d'actes qui sont maintenant cités comme actes interdits. La question qui se pose est que vraiment pour ces personnes qui se trouvent à Guantanamo et que le chef de l'État parti vraiment a demandé qu'il y aurait vraiment un examen périodique de leur situation. Quelle est la nature de cette situation? Est-ce qu'elle est juridique, judiciaire, administrative? Vraiment, est-ce qu'on est dans une situation vraiment de temps de guerre? Ce sont des personnes qui sont liées à un état de guerre. Il y a un qualificatif à donner à toute cette procédure, à tout vraiment cet arsenal, vraiment qui pour vraiment le juriste simple, vraiment sont difficiles à avaler, à accepter. Et puis il y a le fait que les dimensions de l'immunité des personnes qui travaillent dans ce cadre-là fait que vraiment qu'ils ne peuvent pas un jour ou l'autre être transférés devant la Cour pénale de justice. Il y a des accords qui sont conclus avec un certain nombre d'États. Donc il y a une immunité vraiment générale dans le temps et dans l'espace qui fait que vraiment, bien sûr, il y a eu quelques cas qui ont été cités par M. Modvik concernant certaines actions, mais vraiment, est-ce qu'il y a une méthode, il y a une politique vraiment de sortir de l'impunité? Je passe à la question de traitement de la police de Chicago des jeunes de couleur et l'utilisation des armes, le taser. On cite la documentation. On se fait état vraiment de presque au plus de 600 décès par cette arme et qui vise souvent des personnes de jeune âge, et particulièrement entre 8 et 16 ans. On peut se demander pourquoi un État qui a tant travaillé et milité pour les droits civils, qui a réussi vraiment son passage à cette situation vraiment plus ou moins reposante, mais vraiment pourquoi vraiment cette situation se trouve notamment à Chicago? Pourquoi est-ce qu'il n'y a pas des directives? Est-ce qu'il n'y a pas un contrôle? Est-ce qu'il n'y a pas des jugements, des personnes qui se comportent de cette façon, d'autant plus qu'il faut qu'on est dans une situation d'inégalité devant la justice pénale. Pourquoi les personnes de couleur ne bénéficient pas des garanties de la même façon que les autres? Autre question, et c'est la dernière, on fait état vraiment d'une étude qui a été faite par une ONG suisse basée sur des critères définis par l'American Psychiatric Association, qui conclut que les opérations de drones conduites par les États-Unis ont des conséquences directes sur les populations civiles au Yémen. Cette étude révèle en particulier que les femmes et les enfants vivant sous la peur constante d'être victimes, eux-mêmes ou leurs familles, d'une attaque de drone souffrent d'un fort syndrome post-traumatique équivalent à un traitement cruel et inhumain et dégradant. Donc, il y a un impact sur la population. Est-ce que l'État partie est conscient de cette situation? Est-ce que vraiment elle tombe sous l'article 16, c'est-à-dire il s'agit d'un mauvais traitement? Est-ce qu'on peut parler de mise d'un terme sur ces attaques? J'arrête. Il y a d'autres questions, mais je m'en tiens là. Merci.
Monsieur Doma, the floor is yours.
Thank you, Chair. The U.S. story seems to be there was a laudable beginning, and then we strayed for a little while. We are getting back on track now. However, the fact remains that a number of breaches have occurred in between. How, in one form or another, for one reason or another, under one name or another, some overt and some covert. We are agreed now that the prohibition between the state and the convention, that the prohibition of torture is universal, non-derogable under any circumstances, and there is no statute of limitation that can prevent any remedy for it, any inquiry or any prosecution. But the dark days of democracy of U.S. shows that democratic institutions join forces to frustrate democratic principles. This happens through court decisions, through legislative acts, questionable legal advice given and followed, administrative and other measures, all designed to kill the convention and democratic principles. If any lesson is to be learned from what happened for democracies elsewhere, is that the principle of democracy, the principle of constitutionality should not go out of the window in interpreting constitutions, nor should the principle of legality go out of the window in interpreting laws. A number of verbal gymnastics I can find in the report. Anyway, I have no time to go through that. However, how does U.S. intend to live up to its international expectations now, especially correcting the historical and recent injustices by providing a system of complaints, inquiry and remedy, as well as deinstitutionalizing such that everything goes back on track? Two things I would wish to mention. Is there any recommendation? Is there any measure that U.S. can take with respect to the abuses by clergy? About 1,000 victims in the U.S. And there is conversion therapy used to alter LGBTs. Has this been tested before the courts to see its compliance? Does the United States have an extremist list? How does one find one's name in this dark list, in this black list? And how does one get out of his name from this black list?
Mr. Doma, sorry, I have to stop you there.
Thank you,
Thank you.
Chair.
Thank you.
have finished.
Thank you. Ms. Pradam Mala, the floor is yours.
Thank you, Chair, for the time. And before I start my question, first I would like to welcome the delegates and commend your leadership in adopting a global and national framework against the torture. But we also want to see your commitment and values translated in the national and global governance. This committee had raised concern on the Prison Litigation Reform Act that provides no federal civil action may be brought by a prisoner for mental or emotional injury suffered while in custody without showing the prior physical injury. We would like to know your assessment of the Prison Litigation Reform Act and if you have any update with the reform process you have initiated. Although federal government of USA has recognized that criminalization of homeless is a poor public policy of local government, but would like to know from your delegation if you have taken any measures to improve the treatment to the homeless people and if you have any alternate policies to deal with the homeless people. We have many NGOs and survivors with us today. LGBTI detainees have been placed in administrative segregation in the name of their own safety, causing psychological and emotional harm. Conversion therapy, which includes forceful electric shock to change the sexual orientation or gender identity, has a lifelong impact, including suicide. The police harasses many transgender women. Intersex people also suffer from harm as a result of genital normalization, surgery, and forced sterilization. We would like to know from the delegation any measures to ensure safety of these groups. Widespread and systematic sexual violence against children and vulnerable adults by Catholic clergy is now incontestable. Many facts and figures were submitted to the committee during the 52nd session where in the review process of Holy See. Well, the committee has clearly recommended that church officials take effective measures to ensure that allegations are communicated to the proper civil authorities so to facilitate their investigation and prosecute alleged perpetrator. While some have found justice by the American courts in such violence, but they are small in number, the vast majority of them are also bared with many reasons, including with the statute of limitation in case of rape, depending on the state legislation. We would like to know what measures are taking place for addressing the impeding factors for justice, including the amendment of laws, and would also like to know how are you going to repair the mental and physical suffering of those who are still unable to access to justice because of the statutory limitation. Any initiative of the government to ensure access to remedies on sexual violence by military under the U.S. federal system and to ensure justice, it is not a service-related crime. It is a sexual violence and it is a crime against the state. My final comment is on condition of immigrant worker in detention. We see numerous NGOs report of violation of sexual and reproductive rights in detention facilities, ranging from sexual abuse to shackling of pregnant detainees to denial of necessary reproductive health care. We applaud government's adoption of the performance-based national detention standard in 2011 that makes significant improvements in access to reproductive health and medical care. But can the government provide information about how many detention centers are currently implementing these standards? How is the government ensuring these standards are enforced in detention facilities managed by the private corporations? Thank you.
Thank you, Ms. Padamala. Now let me pass the floor to Monsieur Gaillet. The floor is yours, Monsieur Gaillet.
Je vous remercie, Monsieur le Président. Je voudrais commencer par m'associer aux souhaits de bienvenue qui ont été adressés à la délégation des États-Unis, que je remercie moi aussi pour toutes les informations qui nous ont été livrées dans le cadre de ce dialogue. Je salue bien entendu les efforts qui sont faits depuis votre dernier rapport en termes de progrès sur le terrain des droits humains. Et je voudrais me référer essentiellement à votre rapport pour évoquer quelques points. Alors, s'agissant du paragraphe 49 de votre rapport, in fine, relatif au cas de 58 détenus qui ont été transférés de Guantanamo vers d'autres pays. Alors, je crois comprendre que ces transferts ont été réalisés sur la base d'assurance diplomatique. Et je crois comprendre également qu'il y a un suivi qui est fait pour voir si les États destinataires de ces personnes respectent leurs engagements. Alors, ce qui m'intrigue, c'est que si ces engagements ne sont pas respectés, les États-Unis ont la possibilité de procéder à ce que vous appelez des mesures correctrices. Alors, j'aimerais bien en savoir davantage sur le sens de ces mesures correctrices, parce que par définition, les personnes en question sont entre les mains de notre État. Je voudrais ensuite commenter la réponse que vous avez donnée à la question, la question 27B. C'est une question qui porte en réalité sur les statistiques, parce qu'on vous a demandé des statistiques sur les demandes d'indemnisation en matière de torture, les condamnations, etc., les sommes qui ont été accordées, etc. Alors, votre réponse, à mon avis, si je l'ai bien comprise, est cantonnée aux violences sexuelles. Mais je crois que cette question englobe toute la matière de la réparation et de la réhabilitation des victimes de torture, et que la réponse que vous donnez dans ce paragraphe mériterait d'être complétée. Alors, en ce qui concerne l'utilisation des armes à perturbation musculaire, qu'on a l'habitude d'appeler les armes à impulsion électrique, nous avons reçu une information selon laquelle, depuis 2001, 400 personnes sont mortes à la suite de l'utilisation de ces armes-là. Et dans votre rapport, vous indiquez que l'Institut national de justice du département de la justice a procédé à des cas de décès, et il y a des recherches, des réflexions qui sont actuellement menées sur l'utilisation de ces armes. Ce que je voudrais savoir, c'est où en est la réflexion à ce niveau-là. Est-ce que des conclusions ont déjà été tirées? Est-ce qu'il y a des orientations nouvelles, des politiques nouvelles qui sont envisagées en ce qui concerne l'utilisation des tasers? Voilà, c'est les quelques points que je souhaitais évoquer à l'intention de la délégation américaine. Je vous remercie, Monsieur le Président.
Thank you very much, Monsieur Gaye. I guess we have exhausted the list of the members, and I'm the last one remaining, so I'll try to abide the time allocated, and then I had requests from the rapporteurs. If some time is remaining, I will give them maybe 2 or 3 minutes each. So let me first refer to the issue already raised. It's the matter related to the extensive use of solitary confinement in different types of facilities in United States. And can I ask the delegation to provide us data regarding the use of solitary confinement, including data regarding segregated housing units, special management units, and administrative maximum facilities in the Federal Bureau of Prisons, including the number of prisoners in the custody of the Federal Bureau of Prisons who are currently in solitary confinement and have been continuously held in solitary confinement for more than 15 days. For those prisoners identified also in question 1, which I stated, the institutions where the prisoners are held and the number of prisoners in solitary confinement in each facility. Can you also provide us the number of prisoners held in solitary confinement in the last 24 months who have a medical duty status, so-called MDS, assigned for mental illness or mental retardation as set forth in Chapter 2 of the Federal Bureau of Prisons Program Statement 5310.12 Psychology Services Manual, pages 12 and 13. Let me also ask what are the measures, if any, implemented by federal, state and local governments to limit or regulate the imposition of solitary confinement on particularly vulnerable detainees, including children, non-citizens, elderly, women, persons with mental illness or disabilities, and LGBTI persons. Let me ask a brief question regarding the Prison Litigation Reform Act. Actually, we have received a number of reports where actually this act serves as sort of prevention for the victims to seek redress and to submit complaints regarding the allegations of torture or ill treatment. Has the United States determined how many lawsuits alleging cruel, inhuman or degrading treatment or punishment are dismissed pursuant to the provisions of the Act? Let me now refer to the prolonged and indefinite immigration detention. If I may ask, what steps has the U.S. government taken to decrease its use when it comes to mandatory and prolonged detention and ensure that all immigration detainees have the opportunities to seek individualized review of that detention? Why has the U.S. government failed to fully utilize alternatives to detention to limit the expansion of prolonged detention? Let me refer now to the conditions of confinement in U.S. immigration detention facilities. I wonder what steps is the U.S. government taking to ensure that Prison Rape Elimination Act regulations are fully and immediately implemented in all facilities housing migration detainees. Let me also ask that what are the steps by the U.S. taken to fully and independently monitor and investigate complaints of sexual assault, particularly against children and transgender detainees. Let me now refer to the administrative family detention. I have a couple of questions there as well. I wonder why U.S. government has expanded its use when it comes to family detention rather than investing in currently available, effective, less costly and more humane alternatives to admin detention. And also, how is the U.S. government responding to complaints of abuse of immigrants in custody, and what steps are being taken to investigate complaints and sanction correct abuse? Also, what is the U.S. government doing to ensure adults and children in detention can secure legal representation? And last but not the least, I will also refer to the issue of the death penalty. I wonder what measures will the United States take to ensure that it will not subject persons under sentence of death to cruel, inhuman and degrading treatment? And what is the scope of the Department of Justice review which was announced in May of 2014? Thank you for your attention, and looks like we managed to allocate at least 4 minutes for each of the rapporteurs. So let me first provide the floor to Monsieur Bruni and then to Mr. Modvik. Thank you.
Thank you, Chair. Actually, when I ended my statement, I did not mention certain living conditions in detention which are rather problematic. So I just mentioned them very quickly. Apparently in Louisiana State Penitentiary Prison, the death row facility built in 2006 is reportedly deprived of air conditioning or cross ventilation. So the inmates suffer very high temperatures in summer. And similarly, this was reported for the prisons in Texas, and Mr. Modvik mentioned them, so I will not elaborate on it, which caused the death of at least 14 inmates because temperature there apparently, but I would like to have confirmation from the delegation, can reach 65 degrees Celsius. At this what was reported to us. And then it was reported also that the most overcrowded prison system is the system of Alabama, with a rate of occupation of 192%. In other words, in the place available for 100 persons, actually there are 192 living there. But then finally, I noticed, and I wish to underline that I would have many other issues to elaborate, but as you know, time is very limited. So I will go to my last issues, which is under the section of the report dealing with other issues. The United States authorities indicate that they do not intend to take initiative to become a party of the optional protocol to the Convention, nor to accept the individual communication procedure under Article 22 of the Convention. Why? Because, they say, their national legal system afford already the necessary protection to detainees and individuals complaining of abuse. Now, my observation in this regard is that a national legal system is strengthened by the acceptance of international norms and scrutiny. Otherwise, there is no point in accepting the Convention itself or any other international treaties if when a country is convinced of having adequate human rights provision at the national level. Perhaps the acceptance of those international instruments would be a good opportunity to check if the national legal system is really 100% adequate to protect all the individuals under United States jurisdiction. And I would appreciate the comments of the delegation on this point. My last observation is that I'm aware that the United States is the first and most important contributor to the United Nations Voluntary Fund for the Victims of Torture. It ensures something like more than 75%, even 80% of the financial resources necessary to support the projects submitted to the Board of Trustees of the fund. Now, of course, this is a matter of satisfaction, and I encourage the United States to continue to give these essential and substantive contributions to the fund for victims of torture in the future. Thank you, Mr. Chair.
Thank you, Mr. Bruni. Mr. Modvik, the floor is yours.
Thank you, Chair, for granting me a second opportunity. I would like to ask the State Party how you ensure that asylum seekers who have been subjected to torture are properly identified so that they are not inadvertently returned in violation with the Convention. Which training in such procedures apply and which procedures apply? I would also like to ask what is the rationale for continuing to detain non-violent and non-threatening immigrants. Which steps has the State Party taken to decrease the use of mandatory and prolonged detention and to ensure that all detainees have the opportunity to seek individualized judicial review of their detention? More specifically on the short-term facilities, will the State Party make public the whereabouts and holding capacity of short-term facilities for asylum seekers? Which independent oversight mechanisms apply to these facilities to prevent ill treatment? How is the State Party generally responding to complaints of abuse of immigrants in custody? In how many cases have steps been taken to investigate complaints and to apply sanctions in case of abuse? What is the state's official policy regarding the use of isolation in immigration detention facilities? Are there any steps taken to ensure that a directive on solitary confinement in immigration detention facilities is uniformly and properly enforced in all facilities? And my last question, does the State Party have plans to prohibit shackling of incarcerated women during second and third trimester of pregnancy, during labor and delivery, and including any transport? Thank you very much, Mr. Chair.
Thank you, Mr. Modvik. I have a couple of remaining questions and then we can close the session. If I may ask the delegation, can you provide us a bit more information about the so-called Durham investigation into the allegations of torture? We received somehow the information that the victims were not interrogated in the course of investigation, and actually the investigation process looked into 101 cases and decided not to prosecute anyone. So maybe you can provide us more information on that. And last but not the least, let me ask, what steps has the U.S. taken to make good on its commitments expressed most recently during Universal Periodic Review to significantly strengthen protections against racial and ethnic profiling in the context of immigration and border enforcement? And how can these efforts be reconciled with the U.S. government's broad claims of authority to conduct warrantless searches in the 100-mile zone of U.S. borders? So let me conclude here, and let me again express our appreciation to the delegation and also to all the members who asked the questions. Let me remind you all that tomorrow we will convene again at 3 o'clock, and we will be able to listen to the responses provided to the questions of the committee, and we will continue our extensive dialogue with the States Party. If the delegation wants to make any statement, I can give you about a minute for that. Thank you.
Thank you, Mr. Chair. We just want to thank the chairman and the committee members for your comprehensive statements and comprehensive questions, and we will be prepared to have a further dialogue tomorrow. Thank you so much.
Thank you, and we meet again tomorrow at 3 o'clock.